Welcome, debtors and borrowers, to Bankruptcy Bailout, because debt ruins lives, not bankruptcy. My name is Matt Burkus. I'm a Colorado-based bankruptcy and student loan relief attorney, and today we have breaking news out of the Department of Justice. It appears that they're going to be more lenient when it comes to opposing or recommending discharge of federal student loans in bankruptcy. Now, before we talk about that new position, let's do the quick primer on what it takes to discharge student loans in bankruptcy. So the first thing is that student loans are presumptively non-dischargeable in bankruptcy. All right, so if you just file your bankruptcy, you have student loans, you go through the bankruptcy, get your discharge, your student loans are not going to be part of that discharge. The debtor, you, are still required to file what's called an adversary proceeding in bankruptcy court and request the discharge of your student loans. And that adversary proceeding is essentially a lawsuit. You file a complaint, you serve it on the Department of Justice, the Department of Education, your student loan servicer. They answer the complaint, and then you're off and running into real litigation with discovery and sometimes eventually a trial. Okay, so that's what's involved. And so that discourages a lot of people from pursuing it because, one, it's very expensive to do, and the odds of success of actually discharging your student loans are pretty low. Now, the Department of Justice has a new internal policy that they announced today about how they're going to review these cases to determine whether they're going to oppose the discharge or whether they're going to not oppose or recommend to the court to allow the discharge of the student loans. Because up until this point, pretty much the Department of Justice has opposed everybody's adversary proceeding to discharge their student loans. So basically it looks like they're going to become a little bit more lenient, and their stated goal is that they want to reduce the burden on the debtors to get the discharge, and they want to create standardized expectations on when they're going to support the discharge of student loans in bankruptcy and when they're not going to support discharge of student loans in bankruptcy. So and there's three factors they're going to look at, and this corresponds to sort of the status of the law, and we'll talk about that here in a second. So the first is the present ability to pay. Do you have the ability to pay your student loans? And if you're doing your student loan discharge concurrent with a Chapter 7 bankruptcy, well, that's pretty much already taken care of because you've already done your income and expenses. And if you qualify for Chapter 7 bankruptcy based on the means test, which looks at allowed expenses relative to your income, if you have no disposable income, then you don't really have any present ability to pay anything to your student loans. The next factor, and there's two other factors, and these are the big ones that really trip up these student loan discharges. What is the debtor's future ability to pay? So we look at things like, are they at retirement? What is their job history like? Do they have protracted periods of unemployment? Have you been unemployed for 5 out of the last 10 years? Are you disabled? Do you have a chronic injury or a chronic illness? Did you not finish your degree? Do you lack the credential? Do you lack the degree? Or did you not finish basically going to school where you got these student loans? Have you changed career fields? Are you no longer working in the field in which you got the degree? So those are some of the things they're going to look at. And the third factor is, have you made a good faith effort to try to repay your student loans? And I think the key one here that they've stated in their memo is, are you beyond the standard 10-year repayment period, right? Because all federal student loans, the standard repayment term is 10 years. And so one of the yes or no questions they're going to ask you is are you beyond that 10-year period? I think, and this is how we also look at it as well. If you're still within the 10-year period, your odds of getting a discharge, absent something extreme in your situation like a disability or an injury, you're probably not going to get them discharged. But they're going to look at, are you beyond the 10-year repayment history? Do you have a long history of forbearances and deferments? Or did your servicer sort of prevent you, not really prevent you, but discourage you from getting on one of the income-driven repayment programs? Or did those programs not make any sense at the time? So they're going to look at your repayment history. But in general, it looks like what this policy is one is they're probably going to get a little more lenient, and they're going to be a little more forgiving on these factors in making a determination on whether to oppose the student loan discharge. Now, let's talk about what isn't changing. Okay, the law on student loan discharge is not changing. There's been no change in the law. You still have to, or the procedure, you still have to, student loans are still presumptively non-dischargeable in bankruptcy. It's ultimately the bankruptcy court or the bankruptcy judge who has to make the decision. So you still have to file the adversary proceeding. When you do that, the Department of Justice is going to send you an form basically to fill out to look at the very factors that are going to help them decide whether they're going to oppose or recommend discharge. But you're probably still going to have to go to court because ultimately, even if the Department of Justice decides not to oppose the discharge, the discharge of your debt, the judge still needs to make an affirmative finding that you satisfy the factors. So you're still going to have to go minimally, most likely, you're going to have to go to an evidentiary hearing, you're going to have to testify, and depending on the nature of what your reasoning is for wanting the discharge, you may need to get an expert or two in there to testify. It really just depends on the nature of the case. But so you're still going to have to present evidence. You're still going to have to go through the adversary proceeding process. But it looks like the Department of Justice may, in a lot of cases where they wouldn't have before, may take a hands-off approach and be like, yeah, we're not going to oppose it. We'll recommend discharge, or we're just not going to oppose the discharge. And then it'll be up to the court to decide how it wants to handle that when the Department of Justice doesn't want to oppose. So in the big picture, this is still a good thing, okay? This is still a great thing because it means I think there's a lot of cases, and I probably have a lot of cases in my inventory where, these were pretty good cases, but maybe the debtor didn't have the resources to really pursue it, or it was an obvious case, and again, the debtor didn't have the resources to pursue it. This new policy and position from the Department of Justice might make that make some of those cases viable at this point. So there you go, new policy out of the Department of Justice regarding student loan discharges in bankruptcy. It looks like they're going to be a little bit more lenient and have sort of a pre-evaluation process to determine whether they're even going to oppose the discharge. But understand you're still going to have to file the complaint to get your student loans discharged in bankruptcy court, and the judge may ultimately require you to still put on a mini trial, or an evidentiary hearing as we would call it, to at least lay out the bare facts, or to establish the bare facts that justify the discharge of student loans. My name is Matt Burkus. Again, I'm a Colorado-based bankruptcy and student loan relief attorney. I offer bankruptcy to the residents of Colorado, but I can certainly talk to people about their student loans from anywhere in the country. I offer that for an initial consultation fee of $169. Best of luck to you.